right, I'm going to call this meeting back to order. This is the other matters agenda for the code enforcement property hearings. Cases will be heard in the order in which they appear on the agenda. This is a quasi-judicial hearing, which means that the formal rules of evidence do not apply. However, all testimony is taken under oath. So if you are going to testify, or you think you might testify, or there's a possibility that you might testify, would you please rise and raise your right hand? Do you swear or affirm the testimony you're about to give will be truthful and accurate under penalty of perjury under the laws of the state of Florida? I do. Please be seated. When you hear your case called, go ahead and proceed to the podium on my right-hand side. The city will introduce the case. You'll give me an opportunity, especially this is a fine reduction hearing, which seems like these are, an opportunity to tell me what you are requesting and give me the reasons why I should grant that to you. It's important that you do both of those things, right? Tell me what it is specifically that you're requesting and give me the reasons why I should grant that to you. All right, the city can call the first case.
First case number 3933 43rd Street, CE 20010407.
KC 20010407 was cited January 23rd for garbage can placement, saw placement, and outdoor storage. On March 4, 2020, the property was given 5 days or $25 to comply with Code Section 7434A1J, the garbage can placement, and 30 days or $100 per day for the remaining violations. The property failed to come into compliance. The property was out of compliance for 478 days, accruing a lien amount of $47,800. At this time, the city is requesting 15%, and it is the same owner.
Did you say 15, 1-5?
1-5.
Thank you.
Sir, can you tell me your name, please?
My name is Taylor Garcia.
And you are the owner of the property, sir?
Yes, sir.
So tell me what you're asking me for and why I should grant it to you.
I'm asking for a complete lien reduction, and that's it.
Go ahead.
I've gone through and got the property in compliance with every issue. I originally did receive the original.
Well, that I know, right? Because you're not allowed to come here until the property's in compliance.
Oh, right. I did receive the original violation. I was in the hospital with my daughter. Any subsequent documents that were delivered to my neighbor's address via certified mail and not to myself. So I was unaware that any liens were being placed on the house. And the second that I attempted to sell the house, I was made aware that there were liens on the property, and from that moment forward, I've done everything in my power to come into compliance. If I do sell the property as it stands right now with the lien, I'm upside down and are going to end up owing either my title company or the city about $30,000.
Special magistrate, just a detail from this gentleman's lien reduction application indicates that he was in the hospital with his newborn daughter as of early January 2020 for approximately 6 months.
Yeah, she was born January 6, 2020, 3 months premature, and spent the next 6 months in the hospital.
Sorry to hear that. How's your daughter doing now?
She's been bouncing back between St. Mary's and Joe DiMaggio Children's Hospital in Hollywood, Florida. But as of Tuesday, she's back at the house with us, and she's doing great. And thank you very much for asking.
So the city has offered, without me even asking, to reduce it to 15%, which, if my math is correct, would reduce it from $47,800 to $7,170.
That's correct.
Is that correct?
Mm-hmm.
All right, see. My math works okay. That's a 85% reduction.
For sure. I do agree that is a huge reduction, but I do not have the means to pay that fee as of right now.
So I am sympathetic to the fact that things happen, and we get distracted and these things happen. I also have to take into account that I'm on television and people the city watch, and I don't want to give them the impression that it's okay to violate the code sections because you can just come back and wipe them away, later. So I'm not willing to reduce it to 0 because I don't think that's fair to every other person in the city that gets cited, despite what I think are somewhat unique circumstances in your case. I'm willing to substantially reduce it, but can you make me an offer that's not 0?
I'd be willing to pay $1,000 if that's possible.
Does the city have any input on this, or are you guys just stuck on your 15%?
We're willing to go down a little, maybe 3,000. I think 1,000 just wouldn't do. How long the violation? It took 478 days for the violation to get compliance, and although we do sympathize with the fact that he did have an ill daughter, the city did do their part in making sure that the property was posted, so that if there was ever, an issue, that they would receive the notice of violation. And, we try to stay in contact and let you know what was going on with that, so maybe.
If I may speak, I
Let's
did
move on.
receive I did not receive any certified mail. I did not receive anything. I know there's pictures of a notice being posted on my house, but I did not receive any package or notification. It was not there when I got home.
But even on the your lien application, you did state that you know that the property was out of compliance, and that the moment you realized that the lien was ongoing, that's when you did everything in your power to bring it into compliance. So you were aware, based on what you submitted to us, that there was violations on the property. Like we said, we do sympathize with the fact that, like Special Magistrate Wagner stated, that things do happen, and so the lowest the city will go at this point is 3,000.
I did indicate on the application that I knew about the lien, because I did know about the lien when I submitted the application. I was my understanding back in 2020 that I was in compliance because I did not receive any further communications from the city.
Yeah, the city's obligation is the notice requirements in the code. And you have to always remember, right, that their obligation isn't to give you actual notice, it's to follow the requirements that the code says. Otherwise, you get the situation where people would just dodge notice as much as they could, right, and then they would never be held accountable. So they just have to follow the rules, which is they have to send it to the address listed in the property appraiser's records.
It was not sent to the address it was not sent to the correct address, though. I have receipt from the USPS that it was delivered to my neighbor's address.
Hold the phone on that one. Is there evidence that this was not properly noticed?
Not that we're aware of. Everything was,
This was given to me by Monique Williams in the Code Compliance Department when she
Show
told
me
me.
what it is that you're keep holding up, because I can't read it from all the way over there. And so
Yeah, but
why
it's-
do you believe this document tells me that this was not proper notice?
Because the address on there is 937. That is not my address. And that is also not my signature.
so it seems as though the fault is on the post office and not the city of West Palm Beach, because as you can notice on our notice of violation and even the PAPA sheet, it was sent to 933 43rd Street, the address that is listed on the property appraiser's office. And again, because we know the post office at times make mistakes, which is why we make it a point to post it on the actual property and post it in City Hall. No, we can't control the mistakes that the postman or woman makes, but we make sure that notice is sent in many different ways.
That is correct, but that was delivered back to the city with notice that it was delivered to the incorrect address.
But the property was posted.
It was posted as well as City Hall. And someone signed for it, too.
Where does it say on this document what address it went to?
Right under the signature of a recipient. $937. So probably they knocked on the neighboring doors to try and get this thing delivered. Post office does do that from time to time. Technically, the city's notice is still good if they posted the property. They send it to, by certified mail to the address, and they sent it to the right address. The post office appears to have tried several addresses in the area, but they posted the property, which is the obligation if they don't get a return receipt anyway. So they did Part B, even if Part A was an error. And I'll be honest, even if it was an error, that's an appealable decision that has to be made 30 days from the initial case, which we're well past. So even as a question technically of notice, there isn't really a sound one, but I'll tell you what I am willing to do in this case. I'll reduce it to $2,000, make that payable within 90 days. Thank you very much.
Thank you.
Sir, here's a copy of your order. The instructions are on the bottom, yep. Yep, you're welcome.
Good luck with your daughter, sir.
Next cases, 1 and 2 for 728 Talladega Street, CE 09070665 and CE 12030348.
Cassandra St. Hilaire, Code Enforcement of the City of West Palm Beach. Case CE 09070665 was cited on July 16, 2009. On September 30, 2009, the special magistrate ordered 30 days or $10 a day to comply with Code Section 78-6, address characters, and 90 days, $100 a day for Code Sections 1813B, exterior repair. The property failed to come into compliance with Code Sections 1813B and was out of compliance for 216 days, resulting in a lien of $121,600. And Code Section 78-6 was out of compliance for 1,274 days, resulting in a lien of $12,740. Altogether, the lien amounts to $134,340. The city is asking for 25% for this case. This is the prior owner, but they were the cause of the liens, and the liens were actually corrected by the new owners. On August 8th, 2012.
I'm sorry, say that again. The liens were what?
The liens, the violation, the liens were actually caused by this owner, but they were corrected by the new owners.
Oh, okay. So
They-
the property has changed hands,
The
but these are
property
the
has
previous
changed
owners
hands
here.
due to foreclosure.
It's my understanding it was a short sale.
It was,
Not a short sale.
It wasn't
Not a
no
short sale. A deed in lieu.
it was deed in lieu
All right.
of foreclosure.
Finish up and then I'm sure
Yeah.
he'll explain it to me.
Yeah, which is what I was gonna say next. On August 8th, 2012, the property owners voluntarily forfeited the property warranty to One Palm Capital LLC in lieu of a foreclosure. As stated, the property owners could have complied with the magistrate's order, being that at the time, they were still the owners. Case CE 12030448 was cited on March 6, 2012. On June 20, 2012, the special magistrate ordered 30 days, $100 a day to comply with Code Sections 105.1 and work without permit. The property was out of compliance for 1,859 days, resulting in a $185,900 lien. The city is also asking for 25% in both cases.
Sir, can you tell me your name, please?
Yes, Jeremy Pygott on behalf of Timothy and Deborah Rowe. And before I begin, I just noticed this. I just looked down. I think the gentleman that was here before left his cell phone.
Oh, can we get,
I can give it to
I just-
security. I'll give it to security.
I'm guessing he'll
Sir,
come back.
could you just give us the proper spelling of your last name?
Yes, P-I-G, like pig, O-T-T.
Thank you.
Yeah, so what my clients are asking for today is not necessarily a lien reduction per se, but a a ruling of no liability or responsibility as to them individually for the liens attached to this property, and the reason why. And admittedly, it's a bit of a convoluted fact pattern, having a lot to do with the general foreclosure crisis and the timing of all of this. But the bottom line was, in spring of 2009, my clients surrendered the property back to the bank and surrendered the keys and the rents back to the bank. And my understanding of the original violation, and just for the record, while my clients did own the property, they bought it in 2006, and up until the point they surrendered the property, there were a number of violations on this property, of all of which were timely addressed by them. My clients were not derelict in their duties, even though I think they probably felt like they were being targeted because there may have been some suspicion of, renting to folks that might have not been legal. But be that as it may, there were a number of violations that were all timely addressed. But my client surrendered the property back to the bank, and subsequently, the violation upon which this fine has accrued over the years, my understanding was that there was a tarp placed over the roof, and it wasn't done properly or without permits or what have you. But that was actually done by the bank's property manager. My client, again, and unfortunately, due to a series of events that I'll try to explain to you as quickly as possible, the deed in lieu of foreclosure was not actually signed until 2012. But shortly after my clients surrendered the property back to the bank, they filed for foreclosure. The Bank of New York Mellon, was represented by David J. Stern in June of 2009, and I've got some of the foreclosure paperwork here I can show you. But in early 2010, the bank had set their motion for summary judgment for hearing for the foreclosure. That hearing was then dismissed, and then I think in April of 2010, there is a notice of voluntary dismissal filed by the bank, and within that document, they identify themselves as the prevailing party. There's also a final disposition sheet within the court file, the foreclosure court file, stating that the case was disposed by means of settlement prior to hearing. Now, that settlement never got memorialized. Unfortunately, David Stern, as many of us know, in that time frame was wrapped up with his own legal battles, which threw his office in disarray, ultimately leading to his disbarment. And also at the same time, my client's former attorney, Mr. Zaretsky, in the foreclosure case was diagnosed with brain cancer, and he was out of touch for a couple of years. He did recover, and in 2012 he was able to reestablish contact with the bank, and the deed in lieu of foreclosure was signed and it was recorded. But what's interesting is that my clients weren't even aware there was a fine until earlier this year in the spring. They went to go sell one of their properties, and they were notified by their broker, who I guess was contacted by the title company running the lien searches, that there was this very large lien out there, which they had no idea about, because as far as they were concerned, and they never occupied this property. It was always renter occupied. And again, while they had control and custody of that property, they did address a number of violations. But the instant fine that has accrued over the years, resulting from originally a blue tarp that was put on the roof without proper authority, and I guess subsequently there was also a new roof put on an old roof that was done without permits. Again, all well after my clients had put this property in their rearview mirror. So suffice it to say, they were shocked that that there was, and I forget what the number was. My clients had said, I thought they'd said something about $400,000 in fines that had accrued. But, my clients, the position that they're taking is they had no custody or control of this property when these particular violations that have resulted in these fines started accruing. Now, again, I understand there is a lapse in time between when they turn the property over to the bank and when, I guess you would say, the settlement was memorialized by a deed in lieu. But I do think the court file in the foreclosure case is, it certainly suggests that, what my client has, relayed to me, that they turned over the property and didn't look back, that's true. And to no fault of their own, between David J. Stern's office and their own attorney having brain cancer, the deed in lieu was never executed. But be that as it may, I mean, they also didn't have, they didn't have the opportunity to go back in and cure this violation once they had surrendered control of the property back to the bank.
Wouldn't they have gotten the notice, though?
Well, that's what I kind of want to comment on as well. Two things, actually. I just want to point out, the city does not go looking to see if a property is being rented out by
Presumably, the
immigrants.
city sent the notice to whoever
Second-
was in the property appraiser's office, and I think the council's argument is that it shouldn't have been them, but I guess my question is, did they receive the notice? And if they did, why didn't they?
Well, that's why we're here now. I mean, the first time they became aware of this lien, the fine was when they went to sell another property they have earlier this year.
What I'm referring to, because I understand that, and as convoluted as this is, I think I understand what you're telling me. My question is, at the time that the city cited the property, presumably, I don't have the file in front of me, but if it's not true, let me know, but I'm presuming that the city sent notice by certified mail to the address listed in the property appraiser's records, which would have been at that time your client, right?
As far as the property appraiser is concerned, yes, I would expect that would be true.
So I guess my question to you is, that should have alerted your client at that point that there was potentially an individual liability associated with this property for a code violation, no?
What my client's telling me is they never received notice of that lien, that notice of the violation.
Right.
They never received that notice, and I don't know if it was improperly sent but my client, I mean, it was by their own legwork and homework here recently that they were able to.
So your client's assertion is that whether notice was sent or not, they did not receive it?
They didn't receive notice.
Special magistrate, I want to state, they did receive the notice that we sent from the code case and the building case. It was actually sent to the property which they still occupy now, 725 Palm Street, which is what the property appraisers has listed. That's where all the notice was being sent, and we've dealt with.
Was there a certified
Yes, we
return
have,
receipt?
even with the building case, and I could pull the code case where it was sent to 725 Palm Street.
Show it to the attorney first.
The 2009 case has a certified mailing signed by Debbie Rowe. Let me look in the 2012 case. Also, I just want to mention that the documents mentioned by the attorney, the city has not been provided with or had an opportunity to review.
I'm happy to
The prior
provide.
attorney, excuse me, I'm sorry. The prior attorney that was helping the Rose provided let me make sure I'm saying it correctly, I believe the foreclosure complaint, and that has a rider that indicates that they're still responsible to remain in compliance with all ordinances. And I can read that into the record. That
We're
is
talking about documents that I haven't seen. So.
yeah, and that is a 2006 document, and that was attached to a complaint for foreclosure.
Is this the deed in lieu document, or is this the complaint document?
Well, all I can tell you is that the prior attorney provided us a complaint to foreclosure that was it was a 2009 complaint that included an attachment. That attachment was a family rider that was signed in 2006, and it assigned over rents. But it also had a clause that indicated that the owners were still supposed to comply with all ordinances.
Yes, I mean, that was part of the original mortgage.
Actually, sir, if you're going to
Testify,
provide
you gotta come
information,
up.
you have to come up so that it can be heard on the microphone, okay?
Go ahead and tell me
The
your name,
document
sir.
we signed in 2006 was when we
Well,
purchased it.
before you start talking, just so that we're clear on the record, can you tell me your name?
Oh, my name is Timothy Rowe.
Okay, and so you're the owner of the, well, former owner of the property, sir?
Yes.
Okay, go ahead. Tell me what you want me to know.
The 2006 was part of the original 800 pages you sign when you buy a house. And that's the document that she's talking about that was signed in 2006 that has the rider that says that whatever she was discussing. But that's what we signed in 2006 was the original mortgage. It was, the rider. That's all I know.
I have the deed in lieu of foreclosure here also as well as some of the foreclosure paperwork as well that'll evidence that, you know, my clients had relinquished control to the bank. May I?
You have to show it to the city attorney first, please. And while you're traversing that way, the officer will show you the notice documents that she was gonna show me.
I did see where one of those letters was signed for by my client in June of 2012. You know, again, a number of years after they had surrendered control of the property. And after they had already voluntarily dismissed the foreclosure lawsuit due to a settlement to turn the property back over to the bank. And as far as, you know, even if they had, they couldn't do anything about complying or rectifying the code violation when they received that notice in 2012 because they had long since, you know,
Well,
surrendered the control of the property to the bank.
if I could interject here, like we stated, with the documents that we have on the, that was provided by the county database, the foreclosure, the deed in lieu of foreclosure wasn't signed till August 8th of 2012.
As
Even
I was-
the building case was actually, posted on May 7th of 2012 on the Talladega property, right? As well as notice was sent out to 725 Palm Street, the property that your clients own and would live in. And
I think he's making a different argument, right? I think the argument you're trying to make is, or at least if I understand it, is that you wouldn't have had the ability to correct because you didn't have control of the property.
understandable, but as we've dealt with many other residents who've dealt with foreclosure, whether it was voluntary or forcible, they make it a point to, when we go to the actual property and we sent notice it, they will let the code officer know development service building know, hey, we are no longer in control of this property, and they will provide us with the notice showing that they cannot do anything with it, and we will not move forward with our cases because we know that
That's a
they
fair
cannot
point.
do anything with it. We never got anything, no letter, no phone calls or anything from your client stating that they are no longer in possession of this property. So with the city, we are binded by what the property appraiser provide to us. So anytime we would cite the property appraiser still had the Rowe family as the owner. It is not up to the city to determine who now has control of it, especially when we're sending notices to the property that you are actually living in. You're getting them. Understand that you may not be able to do the work at the Talladega property, but you are getting the notices at the Palm Street property. And at any point, our numbers, our emails, anybody could have contacted, whether it was legal, code, whomever, and let us know we cannot do anything because of this, and the city would have made the necessary changes on our end.
Listen, as there are still documents available online, Palm Beach County official documents that are still identifying Mr. Rowe as the owner of the property, and he hasn't been for years. I mean,
Understandable, which is why we're stating the city's point is that may be true, that may be showing somewhere, somehow online in some databases, but it is still the responsibility of your clients when they are receiving these notices to let us know, hey, this is what's going on. We've dealt with many residents that are going through this where they do let us, hey, we cannot do anything right now because maybe we're in litigation, we're going through foreclosure, we're going through this, we're going through that. And the city takes all of that into account and no, maybe we should not proceed with this case because we know that they're not the owners. Let's look for the actual owners and give them proper notice. Your clients, it is their responsibility to let us know these things because as stated by law, what the county provides us is what we can use.
I understand, but I hope you can understand my client's position. I mean, that deed is recorded in the public records of Palm Beach County. You know, I mean, what?
Yes, it was recorded on August 8th of 2012.
I have no idea.
You guys were cited. We have two cases here. One was cited on July 16th of 2009, and then the building case where I guess the work was being commenced without the proper permits was cited on May of 2012. The deed, what we have in the county database is for August 8th, 2012. There is no way that you expect
me,
the city to know that your
I-
clients no
I-
longer own that property.
I think I have an understanding of the city's position and the petitioner's position. The remedy that you're asking me for, I'm not sure that I have the authority to grant. You're asking me to remove your client from the lien.
For any personal liability related to the lien that attaches to the property. I mean, the lien is still valid as to the property. The lien is still valid as to all the prior owners that actually own the property while these violations were taking place. But my client's position is this property was gone and outside of their control when the violation took place that has now resulted in all these accumulated fines. The putting on of the blue tarp on the roof, which was done by the bank, not by my client. It was done by the bank because their property manager had taken over the property, not they did not. Now again, I know it wasn't memorialized, but I mean, it just seems unjust and unfair to saddle them with these accumulating fines that result from violations which they had no part of. It was the bank that did it, not my clients. My client found out about a blue tarp on the roof from a neighboring mailman. My clients own a local laundromat, and somebody had walked in and said, "Hey, look, your old house has got a blue tarp on." He's like, it wasn't me.
The city's position still remains that from our records and everything that we've pulled, that your clients at that time, when CE 09070665 was cited for the address characters and the roof repair, they were still the current owners at that time. That was in July 16th of 2009. And again, as stated, if they were not able to do the work, that's when your clients should have alerted the city that they do not have any rights to that property and provided us with the proper documents so we can attach it to the new owners as you claim. But that was never done.
I notified the city that I had
The only paperwork we have on file is showing that this was signed
on the property.
on August 8th of 2012. These violations occurred in 2009.
Can I interject here for a second, please, so we can do a little housekeeping on the documents submitted by the attorney? The city has no objection to the documents. They are 1, 2, 3, 4 documents from the foreclosure case and a copy of the deed in lieu. The foreclosure case docket, just for purposes of elucidation, it's a very short docket. It does show that Richard Zaretsky, attorney, filed a motion to dismiss once the complaint for foreclosure was filed. The bank tried a default. It was not entered. And then the rest of these documents happened. It's a very, very short docket for a foreclosure. I don't see David Stern's name there, so I don't know exactly where he popped up. So anyway, the city doesn't have an objection.
Thank you.
Everyone, just give me a minute so I can take a look at these.
I didn't see it in here, that's all.
Counsel, why isn't your remedy with your, with the bank?
I have
Seems
no-
like the error here was, if
Not
I understand
having-
your argument, is theirs, right?
What was that? I'm sorry.
Seems like the error that occurred here was theirs in not completing the settlement documents. So why isn't your remedy with them?
With David Stern's office or his former
Bank.
counsel?
Why wouldn't it be a court action with the bank asking the court to find that they're the ones responsible
And
for
it
this?
very well may be. We're here due to the immediacy of the issue for my clients needing to sell this property, but they can't because it's has this lien attached, and that the title company is saying must be satisfied before they can sell. So, I mean, this is just expediency. But
I have two issues that are troubling me about making a decision in this case. The first of which is the city followed, as best as I can understand it, the requirements of the statute. The error occurred in not updating the records appropriately, which was not the city's error. So their notice, as best as I can tell, is proper. The second issue to me is I'm not even sure I have the authority to grant that which you are asking me to do. I can reduce a lien. The code allows me to do that, and I was reading the code section as we were talking, trying to see where that is. but how the lien attaches, I'm not sure that the code gives me authority to change that. The lien attaches as is set forth by the code. So I'm not sure I even have the authority to grant the remedy that you're asking me to grant.
Does the city have does it have the power to reduce the fine just as to my clients and their personal liability? Or is it a all or nothing? I mean, you have to address this lien.
Well, that's a bit of a novel question since, and I gotta be honest, I've been doing this a long time and I don't think that's ever become an issue. The code gives me authority to reduce the lien. I don't know that I've ever tried to reduce it as to one and not another, and I'm not sure the code anticipates such a circumstance.
You know, and the other reason why we're here is, you know, we do have a duty to try to exhaust our administrative remedies before taking this up before the court.
Well, that's fair. That I do understand. I'm gonna ask the city attorney, I know you're talking to the code staff, but,
It does, my client also handed me, there was an email that he had sent to his attorney, Mr. Zaretsky, in October of 2010. I guess one of the code enforcement officers, Glenda Parrish, was in the laundromat and said, hey, look, you need to contact us and, you know, we can try to square this away. He asked Mr. Zaretsky to contact Ms. Parrish and gives him a number, which I'm presuming he got from Ms. Parrish, and maybe he transcribed it wrong, because then subsequently, on October 22nd, 2010, 4 days later, Mr. Zaretsky's assistant then contacts back my client and says, you know, it's coming back with a full voicemail box. I mean, it looks like there was at least some nominal attempt to contact the city, and again, my client, you know, being represented by counsel, I think he was, you know,
I'm not unsympathetic to the situation that your client is in, all the way around, with a substantial lien, a foreclosure case, settlement. These are complex issues. And I'll be honest, more often than not, code enforcement hearings are not nuanced enough to address what I believe is a somewhat nuanced kind of problem here. I don't know, let me throw it to the city attorney. Do you see this differently than the complications that I've brought up, or am I missing something that makes this a little simpler than I'm making it?
I believe that it comes down to a function of, as the special magistrate, your decision to reduce the lien, and that, I believe, is your purview. But I do not believe that outside being able to reduce a lien.
Yeah, I'm just not sure where I have the authority to do that, to give the petitioner the remedy that he's requesting. Even if I were inclined to do so, and I'm not sure that I am under the way that this is set forth, because it seems as if the issue is a contractual issue between the respondent and the bank. I mean, here's what I'm willing to do. I'm willing to accept the city's offer to reduce this. What was your offer?
25%.
Reduce this down to 25%. And then you're going to have to figure it out between you guys and the bank what to do with what's left.
what was the number
sorry.
for the 25%?
Sorry, I had my math. Now it's screwed.
Someone want to do the math for me? And I'll leave this door open for you as well. If you can give me some case law or other supporting material that gives me the right to differentiate here in a way that the code does not, or at least not as how I read it, then you can bring this back for a rehearing and I'll listen. But based on the the legal authority that I'm familiar with and what I've been able to sort of sort through here as I sit here, I don't see that. But I understand this is novel and maybe you want to take a look, so I'd be willing to rehear this if you wanted to bring it. But what I'll do now is I'll reduce it by 75% for each case. Typically, we give a time frame. What kind of time frame do you want?
May I?
Yeah.
my client?
Okay, so the total of both liens together is, in total, is $320,240, $320,240. 25% of that is $80,060. And we would have to break that up between both cases.
Really, three.
Let's just split it evenly between the two cases. I think it's easier to,
Well, we would have to split it up between,
Three little sections.
one case has
Oh,
two
that's
different
right.
fines. We gotta do it.
this case is just like, this case is a very hard to navigate case.
Yeah.
So why don't we do this? Let's take 25% of each of the three totals, right?
Well, well, we can't do that because one of the fines is only
It's only 12,000, yeah.
$12,740.
That would be a good solution, but that doesn't work. So
So-
let's just do,
Hang
let's
on,
do the
it
math.
just-
We'll do 25% of each
It
case.
just takes a couple extra minutes if everybody will remain
do the math.
patient.
Yeah. Let's break it down.
As far as the time frame, Your Honor, I guess the max allowable that you'd be willing to provide.
Well, technically, there really isn't a max. I can pretty much do what I like, but I do try to be reasonable, so you have to give me a,
30.
I'm not doing
Request.
well here. I've got fat finger syndrome.
what is it, November, December? I'll give you 90 days. That'll get you past the holiday. 90 days? Yeah.
Yeah.
I am Cassandra.
No, different Cassandra.
Oh, okay.
What was the code enforcement's girl's name?
Linda Parrish.
Linda Parrish?
I'm still doing one more calculation, I'm sorry.
Yeah, I'm just making sure mine's right too.
All right, well, while they're doing the math, I can't really hear you. You want to come up and tell me what is it that you're trying to tell me about code enforcement?
Hey, let me see the email.
I give you your phone back.
Yeah, I got it.
Let's see.
The girl came to my office, code enforcement, and I explained to her that I.
Go ahead and speak into the mic.
I'm gonna bring you the email.
Did you get these three numbers? One circle up here.
I'll put everything back in here. Hold on, bear with me 1 second.
It was the last page.
There.
Could we see those
You have
first?
to show it to the city attorney first.
This is, when Glenda came to my office,
But you have to speak into the microphone to describe it. I'm
I'm gonna
sorry.
make sure I get her name right, it's Glenda Parrish, right? Right. Okay.
Glenda Parrish.
All right, go ahead, sir.
Okay, my name's Timothy Rowe. Glenda Parrish came to my dry cleaners because I'm only a couple blocks from this property and was going to tell me that there was a notification. And so I notified Glenda that I no longer own the property, and she gave me the information to give to Richard Zaretsky, and this is in 2010, that we no longer own the property. And so there's some place on one of those sheets that she says, we no longer own the property or have availability to do anything with the property.
All right, well,
And then there's Richard Zaretsky's answer on
hold
there.
on, let me take a look.
Special magistrate, this,
This was Richard Zaretsky's answer to the.
oh,
I thought
okay.
it was the same thing.
Richard. I mean, for what it's worth, the city doesn't have an objection to the document in and of itself. I can't speak to what it pertains to. It seems to be a little out of context, so I'm not exactly sure what the point of it is, but
Well, let me take a look, and maybe we'll let the respondent try and explain what I'm looking at. So tell me what I'm looking at.
Glenda came to my dry cleaners because she knew who I was and said there's code violations that she was going to write up on the property. And did I want to go over there and see it? And I told Glenda, I said, Glenda, I don't have access to the property. I have surrendered them. Here's my attorney's name. So Glenda gave me her information. Then I contacted my attorney because the attorney says, don't talk to anybody, because that's why you hired me. So I contacted Zaretsky's office with Glenda's information. And now what Zaretsky talked to Glenda about, I'm sure, was that we didn't have access to the property after that, before that date. But that's what that email's about, letting the city know that we didn't have access to that property. So if y'all can call Glenda, and maybe she knows from 12 years ago what was going on.
I don't believe she works for the city anymore.
That's what happens when you wait 12 years to find out about this. I mean, we signed a thing from Zaretsky saying that it was done. And then I find out 12 years later about this.
Yeah, there's a lot of screw-ups. But, the problem is that the city's not really the city's not the party that screwed this up. I mean, you have multiple attorneys here that didn't manage to get the right paperwork done in a proper amount of time.
I know, hire an attorney because that's not, otherwise you have a fool for a lawyer, so.
I mean, if everything that you say is true, both you and the city are the ones that were sort of stuck with the reality that this is something that should have been done by somebody else and it wasn't done, and yet the two parties that are here arguing are the two that didn't do the paperwork. It still doesn't change the underlying problem that I have, one of which is that the case is still properly noticed, and the other which is that I can't just kick somebody out of I can't change how the city code makes these liens attach. This is just a bad place for the remedy that you're seeking.
Your Honor, as far as a time frame within which to address the reduced fine, I know it's probably an excessive ask, but maybe a year, because my clients are going to have to consider taking legal action against his former counsel and perhaps even the bank's attorney as well for this, this unfortunate delay in getting this memorialized.
What's the city's position on that request?
For the year? Yeah, that's fine.
All right, that I know I have the power to do, so I will do it. So we're going to reduce these to 25% payable within 12 months. Mathematically, I did the math too. Tell me if you came up with the same numbers. That's 3,185, 30,400. I don't know if we did the other one. And 46,475, is that right?
Yeah. 30,400, 3,185, and 46,475.
All right, and we'll give you 12 months, and like I said, my offer remains. If you can come back with some authority that gives me the authority to do what you're asking, I'll hear it. All right?
Thank you.
Thank you, Your Honor.
There's no way, I don't wanna have to hold on to this property for years, costing me $1,000 a month.
Do we have any, I think that's it, right?
I don't know. What's his name?
The city won't hold money in trust.
That's the end of our cases, right? All right, seeing no further, does the city have any further business? All right, seeing no further business before us, this meeting's adjourned.